The Senate Business and Professions and Economic Development hearing for today, and we're moving to item number 4, SB 1165. Senator Cannella, please begin.
Thank you, Mr. Chairman. SB 1165 is a code cleanup and update bill for the Board of Professional Engineers, Land Surveyors, and Geologists. I'll let Mr. Moore from the board go into the specifics of the bill, but as an engineer myself, I can attest to the rationale of these changes. So I'd like to turn it over to Mr. Moore.
Very good. Thank you very much. Witnesses in support.
Good afternoon.
Good afternoon.
Good afternoon, committee members. I'm here to speak about some of the technical aspects of the board and answer any questions about this bill. First of all, one of the things we're trying to standardize is delinquent reinstatement rights. For the engineers and surveyors, it's 3 years for a licensee after 3 years to apply for delinquent reinstatement. For geologists, it's 5 years. With the concerns the board has had over the last couple of decades with allowing someone to reinstate after 10, 15 years without any kind of hurdle and proving that they're still competent, the board first wanted to do is standardize this to be consistent with one avenue of doing it. And they like the geologist approach that allow it to go 5 years, and after 5 years, you would have to start over. So that's one thing that we want to do is standardize that with what the Geologist Act allows. The second thing is separation of the application renewal fee. Our current statute refers to the renewal fee to be set at no more than what the application fee is. We would like that wording to just say no more than the same amount as the application fee. And the reason why is the application fee pays basically is set exactly what it costs for the workload to process an application. And the renewal fee is what we actually operate on over the years. If during fee studies we decide to drop the application fee to, because we're improving the processes, say $10, that doesn't really affect us too much when it's only about 2,000 or 3,000 applications a year. But if we have to drop the renewal fee $10 over 100,000 renewal licensees, that could really make a dramatic ding into our annual appropriation. So we would just like that separation. Apparently, we're the only board under DCA that has that tie. The third situation is signing and sealing for geologists and geophysicists. With engineers and surveyors, they always have to sign and seal any document with their professional opinion or they produce to signify that they're in responsible charge. With the geologists and geophysicists language, they can either sign or seal. And we run into a lot of situations, especially with unlicensed practice, where there's a lot of members of a team that is involved in a geological study, and they're not always signed or sealed by a licensee. And just about everybody involved in any kind of development, whether it's a road, building, anything, relies upon this geological assessments. And we believe that the public's going to be protected a lot better by having a licensee in responsible charge. And lastly, exam versus licensure. A lot of our language for applications it's been around for a long time, and it tends to have the applicants and the professional references for those applicants think that people are applying to take an exam, when in reality they're applying to become licensed. And there's 3 main components to become licensed. There's education, there's experience, and there's examination. And all 3 of them carry equal weight. In some ways, experience in California really outweighs all of those. So we're trying to put clarifying language in there and bring the language up to date with the new world, which signifies to everyone that you're applying for licensure, not just to sit for an exam. And so that's the reason for that cleanup.
Very good. Thank you. There questions from the committee? Hearing none. Witnesses in support? Other witnesses in support? Seeing no one. Witnesses in opposition? No one there either. We have a motion from Senator Berryhill. Seeing no discussion. Would you like to close?
Yeah, just thank you for the consideration. This is obviously a very technical bill that means a lot to the board and to the professionals.
Technical but exciting, Senator.
Well, thank you. I agree. Respectfully ask for an aye vote.
Very good. Thank you. Will the assistant please call the roll?
Motion is due pass to Senate Appropriations. Hill?
Aye.
Hill, aye. Bates? Berryhill?
Aye.
Berryhill, aye. Block?
Aye.
Block, aye. Galgiani? Hernandez? Jackson?
Aye.
Jackson, aye. Mendoza? Wachowski?
Aye.
Wachowski, aye.
That bill has 5 votes. That's enough, but we'll hold the roll open for absent members. Thank you very much, Senator Cannella. Thank you, sir. Appreciate it. Why don't we move to, we don't have other authors here unless somebody's walking through the door. No.
I'll be happy to.
Did you want to present Senator Runner's bill? That would be fine. SB 1228, item number 9. Please, thank you. Senator Berryhill will be presenting the bill for Senator Runner.
She doesn't care.
Very good. Senator Berryhill, thank you for doing
Greg.
that, and please proceed.
Absolutely, and thank you for letting me kind of get ahead of everybody here. I want to thank you, Mr. Chairman, and the committee. SB 1228 is authored by Senator Sharon Runner. She's not able to be here today because of some of the complications that she's had. But this bill models California law after federal law. Very important point. By giving discretion to state agencies and the courts when assessing penalties on small businesses. I want to be clear, this bill is about helping small businesses comply with the complex regulations in California and absolutely not about letting them off scot-free. More than half of California's jobs are generated by small businesses. These businesses are under immense pressure to be in compliance with a vast array of state and local regulations, or be at risk of losing and closing their doors. This can be an overwhelming task for someone who is their own human resource manager, bookkeeper, and general manager. Yet these resilient folks make it happen day after day. But errors can happen. When that error means huge penalties and fines by a government agency, a small business owner has little recourse and is frequently forced to either lay employees off or close their doors altogether. Our goal here today should be compliance, not closure. Federal policies, for example, make it a little bit easier. The handout you have before you summarizes the Federal Small Business Regulatory Enforcement Fairness Act of 1996, signed by President Clinton. SB 1228 would, as in federal law, instruct each state agency to adopt rules that permit waivers or reductions of small businesses' penalties based upon a variety of factors. California courts would, when appropriate, also be given the discretion to reduce regulatory penalties when the fine or sanction would do severe financial harm to that small business. Now, currently, state agencies often rely upon nothing more than a statutory formula for fines, which provides no discretion in imposing penalties, and that's a problem. This bill would ensure that regulators still have the ability to punish the bad actors and at the same time, the discretion to help others comply. The goal here is to see businesses in compliance with the regulations. The system we have now focuses on punishment and doesn't do anything for compliance. This bill takes a step in the right direction, in my opinion. This bill creates much needed flexibility, and I'm happy to add my name as a co-author. I want to thank everybody for being here today, and I'm going to ask your aye vote at the end of the day for this bill. With me is Ken DeVore of NFIB and Laurie Kammer from Small Businesses California in support. I also have Charles Fennessy of Senator Runner's office here to answer any questions that you guys might have.
Very good. Thank you, Senator Berryhill. We'll start with witnesses in support and comments. Very good, sir.
Thank you, Chair and members. Good afternoon. Ken DeVore, the National Federation of Independent Business, on behalf of 23,000 small businesses in California. One of the things we're seeing is, regulatory agencies, they don't have the flexibility, and so a small business gets the same penalty as a big business, and consequently, it costs many times more, about 40% more to comply with regulations for small businesses. And I've looked at the list, and there's several hundred regulations introduced a year. And the purpose of regulations is to, bring about compliance with rules and not to put a business out of business, not to put them in such jeopardy that they can't provide the jobs that they're doing. And the bill is very, I believe, well drafted. And the bad actors, if it's a criminal act, then, there's no provision there for them to have flexibility. I mean, if somebody's committing a crime or, if they're just flagrantly disobeying the rules. But one of the things, and the bill also directs agencies to help small businesses. I personally sat in a meeting with a senior top enforcement officer from a very big agency in this state, and they fined a small business $120,000. And it was an issue, and the small business owner sat there, and the president of the business was like, what can we do to fix this? And they listed all the steps, and the compliance officer looked at him and said, it's not my job to help you fix it. It's my job to make sure you do. And when we have that mindset, they still left the meeting with no clear idea on what to do to fix it, except now they have a $120,000 fine. And it wasn't an egregious thing. And we see these types of fines, and they don't have flexibility. And so this sets up a framework for the agencies to draft regulations to do a means test. I mean, if you've got 5 employees and you own a little deli, and you are violating some regulation that maybe you weren't aware of, and I understand ignorance of the law is no excuse generally, but these people, and to add to his list, they're their own compliance officer as well, and they don't always know that a new regulation passed until an inspector walks to their door. They're trying in good faith to obey the laws and to create jobs. And I think that this sends a strong message that California is going to be customer service oriented. Our agencies are here to serve businesses as well, and to, along with forcing compliance. So we strongly urge your support on this.
Sorry, thank you very much. Next witness in support.
Good afternoon, Chair and members. Lori Kammerer on behalf of Small Business California and also National Association of Women Business Owners, Sacramento chapter, in very strong support of this bill.
Very good. Thank you very much. Others in support?
Hi, Anthony Molina on behalf of the California Manufacturers and Technology Association.
Very good.
and
Thank
support.
you.
Thank you.
Yolanda Benson with the California Asian Pacific Chamber of Commerce, also in support of the bill.
Very good. Thank you, Yolanda. Appreciate it. Others in support? Seeing no one, is there anyone here in opposition? Very good. Bringing it back. Any questions or comments? I'd like to just, if I could, before you close, Senator Berryhill, I really, I went through this, and as someone who is a small business owner myself and who has had numerous, not many, but numerous challenges sometimes with the regulations and with government agencies, which are very difficult to maneuver. So I agree with that, and actually joined NFIB a long time ago after one such episode. But I just have...
All it takes is one.
All it takes is one. That's very true, and you change your attitude very quickly. But I just have a problem with the workability and the applicability and the practicality of trying to implement this with the state agencies who now do. And we need to weed out those bad actors that you were talking about that really have no sensitivity to what a small business owner has to go through to succeed in this state today. And I think that, but they do have the flexibility, and we need to work within that system. I guess I'm struck by, and you mentioned it, the ignorance of the law is certainly not, it's not considered an acceptable defense in our judicial system. And this really would make that, that principle, this bill would allow ignorance of the law to be an adequate defense. And I think that's a troubling, and it also compromises, I think, the Administrative Procedure Act by allowing a judicial appeal before a business had really filed their administrative remedies through the system, which also makes a challenge. So we need help for small businesses. I don't think this is the one that's going to get us there, and I'm unprepared to support the bill today, Senator Berryhill.
All right.
Sir, if I may, it's my understanding that the measure only allows that particular instance of an appeal to a court in the instance that a agency has not written rules. And that happens frequently. A lot of agencies take a long time dragging their heels and actually drafting written rules for businesses to comply with. And so it's my understanding that's the only instance where they would have a judicial remedy.
Mr. Chairman,
Of course.
if I may, I'm Charles Fennessy. I'm with Senator Runner's office. In fact, the primary provision, reason for that provision that the business could go directly to court was only in the instance that the agency had failed to promulgate rules. Yeah, and the rules and the structure of the rules are similar to those that are in the handout where the Department of Energy, those are the federal standards that were the basis for this bill. The judicial review elements were only to ensure that the agency went forward and did in fact create rules that would allow for at least potential of reduction of penalties. And there are express provisions in most of these rules by federal agencies that say if the offending business is a repeat offender, if the violation constitutes a crime, if there's an intent to violate, that they get no relief. So those measures could be built into the system. They are part of the federal fabric. And the underlying principle with the federal law is that the agencies are supposed to assist small business with particularity. Large corporations have compliance departments, they have counsel. Small businesses obviously are generally unable to afford those things.
Thank you for that. Other questions or comments? Yes, Senator Wachowski.
I wanted to get a better flavor of the federal small businesses, because as you've articulated, there's, you don't want repeat offenders, you don't want it to affect health and safety, you want a good faith effort has been done. How has that worked out for the small business person under the regulations and the federal government?
Well, in the federal law, the judicial review aspect of it allows the court to contemplate whether the action of the federal agency was reasonable. And if the federal agency was unreasonable in the demand of the small business, then the federal courts can grant attorney's fees to the small business. We didn't go that far, but in terms of how it works, the agency's on notice that if they're unreasonable, they can not only lose their order, but they may have to pay fees, attorney's fees to the small business.
How has it been on the front end? What has been the data that, this is 20 years? So has the Small Business Administration found mitigating circumstances for leniency in applying rules for small businesses, or have they not applied this at all? It just nobody fits in. Well,
apparently they have.
How is this used?
Yeah, apparently they have applied it, and we don't have a litany of cases. We could find additional support, but the way they've structured it, this was the second of two major bills that were directed to this end. The 1996 law was the product of an executive order by President Clinton to study the problem. Agencies not granting flexibility, agencies with no discretion other than to apply a formula. And they came up after a couple of years study with this mechanism that we've described, and we've tried to replicate it to the degree that it's applicable in state law. And it appears that it's lasted for 20 years, which can be construed that the problem wasn't recurring on the same level as it had. There was an 86 law and a 96 law, but not one that followed. And part of it was the grant of this authority to federal courts to monitor, to regulate the regulators.
Right, and I think if I'm reading from page 3 of the bill, it's under section 2, but I guess it starts at page or line number 9. The court, it's only after the administrative remedies have been exhausted. Normally, if there has been a rulemaking determined and the state agency whacks you with a big fine, then you actually have this has created a cause of action to go in and to say, or the cause of action was already created. Now you can go in, you can say, at the mercy of the courts, you argue equity, right?
In most instances, that would be the process. That's the process now.
Right.
You exhaust the administrative remedies and their appeals. You go to court. The court can review, but under current law, all they can review is whether or not the agency exceeded its jurisdiction. So they can't get into whether this particular actor was acting in an egregious way. In most of our laws, when we apply punitive damages, we're requiring that the act in some sort of repugnant manner or engage in fraud or something along those lines. Here, we don't give them the type of discretion that, say, a peace officer would have.
Right, and then you have the statute where you say the agency, the trier, the court would be able to look at the leniency factors
Precisely.
and saying you are a small business. Okay, tell me what you did to try to comply with it and what were the efforts that you made. All right, I understand.
You know, and just to add to that, I mean, one of the problems is that, yeah, you can take this stuff to court and whatnot, but at the end of the day, these are small businesses. And a lot of times you're broke before you ever get there because of the lawyer fees. So, I mean, you know, we do so much in this country, and we claim that we do so much to help the small business factor out, which is the backbone of this state and country. And yet, when it comes to these types of agencies that are used to just, you know, ruling with an iron hand and doling out these fines because of a model that, whatever that model might be, there's no flexibility there. And I think it's the small business guys fighting and scratching, you know, with all the different regulatory burdens that we have. They do a pretty good job. But there's sometimes, these are just backbreakers. And if there can't be a little bit of flexibility to be able to let these guys get into compliance, this isn't my bill, but I think it's a good one. That's why I'm a co-author on it. I think Sharon's got a good idea that I think would be good for the state of California to adopt.
Mr. Chair, could I give you an example of where this would have helped, a very short one? There was a gentleman in Southern California just a few years ago that was funny, I couldn't make this up. He was a worm farmer. Raised night crawlers, fed them cardboard, recycled cardboard, and collected the castings. It's a fertilizer, one of the best fertilizers known to man, but it has a unique property. When a plant absorbs it, it makes a plant more naturally resistant to pests. They start producing more of the enzyme chitinase, which repels pests. And consequently, he was fined by the Department of Pesticide Regulation for $100,000 for selling an unlicensed pesticide in California. And it was just worm castings. He actually went to court on this, and the court determined that the judge said in his ruling that he thought it was ridiculous, but he had to uphold the law as it was written. They followed the letter of the law, but he couldn't, that's what the fines are. $100,000 fine, and the same thing happened to another gentleman selling cat litter made out of chipped up pine. Old pine boards made little pellets, but because pine is naturally antibacterial in nature under our broad definition, it's now a pesticide. It cost him $70,000. It's my understanding he's no longer in business in California because of that. So those are two examples where a little flexibility to, lower a fine for somebody who, was trying to build a green product that we thought DPR would be happy with is, so those are, thank you.
And I'll take that as my closing also.
Very good, thank you. Yes, Senator Galgiani.
I'm prepared to move the bill, but I want to thank the author and Senator Berryhill for this. And I think it should be government's job to help businesses sometimes to come into compliance and to be there to help them succeed rather than to be there and hope that they would fail so that money could get collected to help grow the agency, if you will. I just wish this could also do something about the ADA lawsuit issue that we have, where I see that it's now moved into the Bay Area after hitting my district very hard for businesses who thought they were in compliance for very small technical things that otherwise they thought they were meeting the intent of the law. And I don't think that we should be waiting for business to fail and then seizing upon that opportunity, but rather appreciating that they create the jobs. It's the business community that creates jobs, not government. And so I thank you for bringing the bill forward, and I would like to move the bill.
Thank you. We do have a motion, and I'll be with you on that the ADA legislation you're coming up with, Senator Berryhill. So we do have a motion from Senator Galgiani. This will be due pass to Senate Judiciary Committee. The assistant, please call the roll.
Hill?
No.
Hill, no. Bates? Berryhill?
Aye.
Berryhill, aye. Block? Galgiani? Aye. Galgiani, aye. Hernandez? Jackson? Mendoza? Wachowski?
We've still got room, Mr. Chairman.
What's that? 2-1 at this point. Very good. Thank you, Senator Berryhill.
Thank you. Thank you, guys.
Senator Runner's behalf. We'll now move to Senator McGuire. This would be item number 5, SB 1174.